Thank you, Mr. Chairman, and thank you, Administrator McCarthy, for being here. I know you've been here for over 2 hours and appreciate your testimony here today. I know a couple of my colleagues have asked about the proposed Waters of the U.S. rule, and in my district in Illinois, I represent a fairly heavy ag district, and I think the frustrating part for me is when I travel around my district and I talk to people, you know, they ask all the time, well, you know, Darren, how did this law get passed? What happened? How did this law get implemented? And I explained to them that this isn't in fact a law. This is a rule implemented by EPA that really circumvents the Congress and circumvents the Constitution in a lot of ways, and that really unelected people are putting this rule. And you also couple that with the real world effect that this rule is going to have on agriculture, whether that's a puddle or it's a stream or it's a creek on a farmer's land. And when I travel around my district, I can't find anybody that thinks this is a good idea. And you look at a rule or a law or a statute as fixing a problem. No one in my district thinks that there's a problem that needs to be fixed. And I also would point to you that back on October 9th of 2015, the Sixth Circuit Court of Appeals, second highest court in our country, issued a stay on implementation of the rule on the waters of the U.S.
Yes.
And that decision, written decision, stayed that said this rule cannot go forward. In there, they specifically cite a significant legal question as to whether certain parts of this rule are supported by science. Now, that's not Republicans saying that on Capitol Hill. Yep. These are two independent judges, second highest court in the country, saying this. So when I look at that, I guess my question to you is, do you disagree with the court on the basis that this rule lacks science?
Well, far be it from me to disagree with the court. We are going in, hopefully, with the full information available that we have, that the court will have through oral arguments in our briefings in the record, that the court will agree with us, that is well documented, why we came to the decisions we made on the basis of science and the basis of the history of our Oz and Army Corps' experience here. You know, one of the biggest frustrations I have is the fact that I think the agriculture community really, we would benefit from further discussions on this because we have actually expanded the exemptions for agriculture. We have provided clarifications that should allow them to produce the food, fuel, and fiber that we rely on. We did everything we could to make sure that it wouldn't add any permitting issues or responsibilities to the agriculture community. We did everything we could, not just to protect their interests, but to make their interests clearer and more sustainable.
Well, I appreciate that, but I mean, again, that's not what the Farm Bureau says. That's not what the Illinois State Farm Bureau, the American Farm Bureau, I don't think you're going to get that from anybody in agriculture thinks the way you're doing. And I think the other thing is there was lots of talk and rhetoric from the EPA and the Corps is, we're going to listen to your comments. Give us all your comments. We're going to listen to them. We're going to take them into account. And I've seen the detailed, merit-based comments that were given to you and your department and the Corps. And all of them, in my estimation, fell on deaf ears. None of them were taken into account when you look at the rule and how it's implemented and the effect that it has on them. And it's consistent in the agriculture community that people are absolutely opposed to this rule in the way that it's being put forth. The other thing that I would mention to you, you know, this, as you implemented this rule, you abided by the Administrative Procedure Act, the APA, in doing that. And you testified back on March 4th, 2015 in the Senate, and Senator Sullivan from Alaska had asked you about the WOTUS rule, and you, concerning the APA Act and following that, you said, there have been, quote, there have been individuals representing various constituencies in the states that have commented, but we have received over 1 million comments, and 87% of those comments we have counted thus far are supportive of the rule. I find that absolutely hard to believe. Is that still your statement today?
That is my understanding when folks looked at the record. That's correct.
87% is supportive of this rule across the country.
Comments, yes.
And has that changed since then? That was your testimony on March 4th.
I don't know. I haven't surveyed folks throughout the United States at this point to see whether or not they still would feel the same way.
And can you name for me any agriculture groups that are supportive of this rule today?
I probably can't go down that road, sir. I know there's a lot of concern among the agriculture community. I think we've received certain letters and support from individuals. Whether or not there's any association, agriculture association, I can identify. I don't think I can.
And my time's almost up. And you're also aware there's another federal district court in the Dakotas that has also issued a stay here, and for many of the same reasons that were done in the Sixth Circuit. I think that was at the federal district level. Are you aware of that also?
Yes.
Thank you. Those are all my questions,
Okay.
Mr. Chairman.
Thank you, Mr. LaHood. And the gentleman from Louisiana, Mr. Abraham, is recognized.
Thank you, Mr. Chairman.